Yes, it is your number one authoritative business radio, the only radio station online that you will get all the authentic business information, the economy, capital market, money markets, personal finance, generally. And it's your regular program, Investors Education Series. And I still remain your uncle, Charles Farquhar. So today on Investors Education, we'll be looking at something very, very important, and it is for everybody as long as you earn an income, no matter how small it is. And in this part of the world, Africa, yeah, even Nigeria, we don't even look at it. So what's the topic? Estate planning basics. Estate planning basics. Yes, we need to understand how to plan your estate. But in Africa, yeah, especially in Nigeria, yeah, when you now tell somebody that you need to plan, your estates, you need to plan how your assets, will be distributed when you are no longer here. People say, oh, they will begin to arrange family meeting for you. Oh, you want me to die, And so I will say, how much do I even have for me to begin to maybe have a will, as the case may be, But today, on Investors Education, we are going to see that you don't necessarily need to have so much money. As long as you earn an income, you have relatives, even though you are married or you are not even married, so that when the good Lord calls you, you are no longer on this planet. Then all the things you have, your little assets here and there, your income, your benefits, it will be distributed according to your own will, according to what you wanted if you were still alive. That is the essence of estate planning. That is just the basic, essence of it. And it is not expensive to perform. So today we'll just look at it briefly. But before I go on, I just want to quote from, I think, an unknown author. Always plan ahead. It wasn't ready when Noah built the ark. Estate planning is the only gift you can give to your family when you're no longer here. And somebody has asked me, why do I need to do estate planning? So these are some of the questions we're going to answer in the course of the program today. So what is estate planning? Estate planning is a process of arranging and managing your assets, your properties, and finances to ensure their distribution according to your wishes after your death. Arranging and managing your assets, your properties, your finances to ensure their distribution according to your wishes after your death. What are some of the basic components of this estate planning? Normally, yes, you need to have a will. And in one of my financial self-appraisal, I ask people towards the end, have you written a will? I see the change in their face, and all that. But it's a necessary thing. We cannot hide away from death. Death will come one day. But we are saying, when it comes, what are the plans we have made? So one of the main components of an estate plan is your will. It's a document that outlines how you want your assets to be distributed after your death. Yeah, you can use that. Then you also have a trust. Legal arrangement that allows you to transfer assets to beneficiaries while minimizing taxes and maintaining control. You can have a trust. Yes, you can have a trust foundation. You can say Lagbaja Trust, and under that trust, you name the beneficiaries. You can also be the grantor of that trust, and while the people you have named are the beneficiaries, so you don't even need a will. Okay, then we also need a power of attorney, a document that grants someone the authority to manage your financial and medical decisions if you become incapacitated. Beneficiaries. Naming beneficiaries for life insurance policies, retirement accounts, and other assets, So these are some of the basic, some of the key components of your estate plan. Of course, you need to just meet an estate Anthony, that will guide you as to what to do. It does not mean that once you write your will, then you are going to die the next day. You can even review your will. You can even have additional, to your will, what lawyers will call your codicil. That is, I have property ABC, and I'm still alive, I acquire more property, but I've already written my will. So I can do an addendum, that is a codicil to that will I have, made earlier. And your will doesn't necessarily need to be written. Yes. Anyway, we shouldn't go into those technicalities. When you meet your Anthony, your lawyer, they will advise you on it. So let's just create that awareness as to what you need to do. Just know that, yes, these are the things you need to do. So specifically for stockbrokers, we come across people who had shares and they die. And of course, the family, the wife and children, they don't know how to go about it. So, and that is why it's an integral part of stockbrokers training. I also advise it for any investment person training. So, and that's why you see some stockbrokers, they tell you that is their specialty. They call it Admon cases. Estates. That is what they do most of the time. And all that. So, and some of them have become so proficient in it. They're even experts, even advising the lawyers as to what to do. But it is just for those shares, and all that. But we know that when it comes to writing of your will or your trust, your properties might not be only on your assets might not be only shares. You can have landed property, business interests, and all that. So we have seen these components of estate planning, some of the key components. Let's now look at the estate planning goals. What are your goals you are planning your estates? Asset distribution. Very, very important. Ensuring that your assets are distributed according to your wishes. That is the most important thing. Then, of course, you want to save the beneficiaries from, paying so much tax. Yeah, so minimizing taxes and fees associated with transferring your assets. Now, in stockbroking, what we call transmission, transfer. Let me even say nominal transfer. Now when you say nominal transfer, you are just transferring those your shares, related parties, maybe from the father to the son or the father to his business, related parties. That is nominal transfer. You are not going to pay consideration. Okay? But those statutory charges will be paid. That is a nominal transfer. Now, when you now talk of transfer as a normal transfer, you buy shares, you go to the floor, your broker assists you, you buy those shares and all that. That is share transfer. Okay? Now, when you now talk of transmission, that is, you are now trying to transfer the shares, or can I even use the word, the properties of the dead, transferring to the living beneficiaries. That is transmission. And a lot of process has to be in place before you can actually do that transfer. Okay? So, You are trying to minimize tax for the beneficiaries. Then incubator protection, protecting assets for beneficiaries who may not be able to manage them themselves. Maybe your children are still minor. You have to appoint guardian for them, that will manage it for them before they come of age. You're also looking at your business succession, ensuring the continuation of your business after your death or incapacitation. Then charitable giving, including charitable donations in your estate plan. Yes, some people, in fact, we have seen cases, they will say they will all their so and so property to a particular charity. Maybe while alive, they'll be supporting that charity. Then what are the tools, the estate planning tools that you need? Probate. Probate is just simply giving authority to that your will. The court supervised process of settling your estate after your death. So you need to go to probate registry. Trust administration, the process of managing and distributing assets according to the terms of the trust. So you can see, you can use your will, you can also use a trust. Then of course your estate tax planning. Strategies to minimize your estate tax, such as gifting and charitable donations. Then of course your asset protection. Strategies to protect assets from creditors and of course various lawsuits. Okay. Now, what are the best practices? You have to review and update regularly. Review and update your estate plan to reflect changes in your life and your assets. Like I said earlier, if you have not acquired a new asset, you need to, reflect it in your estate plan. Seek professional advice. Consult with an attorney, a financial advisor, your stockbroker, or other estate planning professional to ensure your plan is comprehensive and effective. As we speak today, especially in the capital market, we still have a lot of accounts. People have died, and their ratios are not coming forward. Nobody is coming forward. So, and that is why we, and on Broad Street Radio, we want to create that awareness. In fact, I've given a lot of lectures concerning estate planning, admon cases, and all that, so that people should come. They should come out with all the necessary documentation. Some of these accounts, some of these assets, can be transferred to the genuine beneficiaries. And in my practice as a stockbroker, I have seen it several times. And at times it's so painful that children of deceased parents will be suffering, not knowing that their mother or their father has assets that can take care of them all their lives. And this is also an appeal to those of us that are still living. Please ensure that at least your spouse or even your grown-up children are aware of some of the investments you are doing. I must also say, give kudos to some of the managing directors of stockbroking firms that have taken it upon themselves to ensure that due diligence is followed meticulously when cases of admon, as the case may be, come to them or when they notice it. Okay? So, communicate with beneficiaries, inform your beneficiaries about your estate plan and the roles they will play. This time around, also consider your digital assets. Include digital assets such as social media accounts, cryptocurrency in your estate plan. Now, in all this process, people will tell you, the man died intestate. That is, there is no will. And for the beneficiaries to begin to claim his asset, They need to go to court to get a letter of administration. That takes a lot of time. Yes. And that is why we are saying ensure that your children are aware of some of the investments you are doing so that they can take it up from there when you are no longer alive. And even let your spouse be aware. Because I've seen cases, in fact, there was one particular one that, yes, a trainee broker. I think she was just doing training, in a stockbroking firm, and she went to visit a friend whose father died. And as they were cleaning the man's room, then it was a lot of this dividend warrant. And the lady was just trying to just clear them and just throw them away. And this trainee broker and I said, this document looks very important. These are dividend warrant. He said, they all belong to my friend. I don't even know what he's doing with it. And this trainee broker and I said, no, these are very important documents. And they looked at it, they saw all the share certificate, everything. And apparently, the children, the wife, don't even know anything concerning the man's investment. So it was this trainee broker that now assisted them, looked at everything, took them to our office, called the man up. Apparently, the man died without a will. So they had to go through that route of getting the letter of administration. At the end, though it took almost 6 months to hear about, at the end of the day, they were able to recover a lot of money. So you can see. So we need to understand probate. Understanding probate. Probate is the court-supervised process of settling a deceased person's estate, including paying the debts, taxes, and distributing assets to beneficiaries. Let us review it and see what that is. Of course, you go to the probate registry. I'm in Lagos here, in Lagos High Court, there in Ikeja, where you be dealing with the probate registry. So for the probate process, of course, when the man dies with a will, yes, the will is there, but they will still need to go for probate. He has executors, which are his personal representative. Then you will say he died testate. Now, without a will, you will say he died intestate, and they will go through letter of administration, and of course, administrators will be named. So, in all this, the court is giving them legitimacy to handle the estate of the disease. So, the first process is filing the will. The executor or the personal representative file the will with the probate court, appointing the executor. Now, the court appoints the executor or personal representative to manage the estate. So they now need to notify the beneficiaries and, of course, the creditors, then the inventory and the appraisal, paying the debt and taxes. You just pay all the charges, pay to government and all that. Then at the end of the day, you distribute the assets, The executors distribute the remaining assets to beneficiaries according to the will. As long as there is a will. Then, if there is no will, of course, the administrators will look at all that. Now, you can have testate probate. The deceased person left a valid will. You can have an intestate probate. The deceased person did not leave a valid will. That is the letter of administration. Now, some persons have said you can also avoid probate. That is, you don't even need a letter of administration. You don't even need a will. If you have a living trust, you transfer assets to a trust during your lifetime. You set up a trust, and all your properties belong to that trust. While alive, you can be the trustee. Okay, or you can give it to professional trustees, and you list all the beneficiaries. there. You can also have joint ownership of your shares. So at certain points, you set up a company. You are the managing director. Your wife and children are directors. And all the properties, whether they are landed property, their shares, they are owned by that company. So in the case of death, directors will just meet and change the signature. And they continue to get the benefits. But there is this, what is even being done these days now is pay on debt. That's POD. You can also have such an arrangement. But as you are doing all this, please talk to your estate attorney that will advise you properly. What are the benefits of probate? Of course, it's court supervised. It's a clear title. Then also creditors are also being protected. But we have seen when you are trying to do probate, especially without a will, letter of administration, it takes some time. Minimum of 6 months before that letter will be out. And of course, you now come to the stockbroking firm, you meet the stockbroker who will now assist you as to how an estate account can be opened. You go to the registrars at that time, and of course in CSCS, and an estate account, everything, the banker's confirmation, everything is now being done. So I will advise that you have a competent stockbroker who has the expertise concerning this estate issue. Here is some firm, those in operations, you have them, and they are very good at the processes, and they make it easy for you. But always also have an estate attorney that will advise you appropriately. But when it comes to the shares, your bonds, your shares, the stockbroker will work in conjunction with your estate attorney, and at the end of the day, you will get value for the assets of your deceased relative. So probate is necessary process for settling a deceased person's estate, but it can be time-consuming, costly. Yes, it can be time-consuming and costly. Understanding the probate process using probate technique can help minimize the impact of probate on beneficiaries. It's very, very important to understand that probate. Now, I just want to talk briefly on letter of administration. A letter of administration is a legal document issued by a probate court granting a person the authority to manage and distribute the estate of a deceased person who did not leave a valid will. Like I said, I will not go into technicalities of what is a valid will. The lawyers will take care of that. Purpose of a letter of administration. The primary purpose of a letter of administration is to appoint an administrator. The court appoints an administrator to manage the estate, pay debt, and distribute assets to the beneficiaries. Establish authority. The letter of administration establishes the administrator's authority to act on behalf of the estate. Then provide proof of authority. The letter of administration serves as a proof of the administrator's authority to manage the estate. So that is why you need stockbrokers who have expertise in that area to guide you, and of course always have an estate attorney to be part of that team. There are a lot of requirements, for you to get the letter of administration. So many, in the early days as a investment executive, those are some of the things you are trained on. Yes, some of the requirements for you to get, you say, the death certificates, so many documents you need to bring, notice to interested parties, all the requirements the stockbroking firm will give you, and of course, in conjunction with your estate attorney, you can now go to probate registry and go through that process, which is very, very important. And my appeal would always be, yes, ensure that you are dealing with a stockbroking firm. Okay, now it is a trading license holders that, of course, they are all registered with SEC. Ensure that you are dealing with the right people, and ensure that the managing director of the firm is aware of these transactions, and of course the compliance officer, the stockbroker. Don't go by the wayside and we want to use one or two persons. We have seen so many issues when it comes to that. So what is the responsibility of the administrator? We have said managing the estate, distributing the assets, then accounting and reporting. The administrator must provide regular accounting and reporting to the probate, to the interested parties, for those who are managing the estate for. So that is the basis of estate planning. And again, it is one of the components, that is estate planning, of a comprehensive financial plan. So when we talk personal financial planning, estate planning is also one of that plan. So that at the end of the day, when you leave this world, then those you have left behind will not have cause to begin to have so many regrets. And you too, whatever realm you now find yourself, you continue to, maybe they say rest in peace, or you continue to grow in strength as you journey towards meeting your creator, in better luminous realm. You'll get there and you'll not be thinking what you have left here on planet Earth, whether your beneficiaries are fighting quarreling with each other, because you have made that arrangement before you finally leave. So it's a it's a responsibility on your part to ensure that before you depart this planet, this world, you have made arrangement for efficient and proper distribution of your assets while you are still alive. So before I close the show, let's take a quote. Estate planning is an important and everlasting gift you give your family, and setting up a smooth inheritance isn't as hard as you might think. It was given to us by Suze Oman. A goal without a plan. A goal without a plan is just a wish. So, in your financial planning, you must have, as your one of the component, an estate plan. Do something today that your future self will thank you. Peace of mind. Planning is bringing the future into the present so that you can do something about it. And finally, we make a living by what we get, but we make a life by what we give. So your estate plan, it's something that you need to give to your beneficiary. So at the end of the day, you will smile. While they are alive here, they will also be smiling and happy, and you too will transit to a better realm, and you go and give accounts to your creator. So let's begin to look at it. Getting the basis of estate planning is key for everybody who earns an income, no matter how small. Always plan ahead. Like I said earlier, it wasn't raining when Noah built the ark. Thank you.